Good morning, Jack.
Morning, Bob.
We had a decision out of the district court in California about the LA deployment yesterday. So let me kick it over to you and ask you for some first reactions, and we'll take it from there.
Sure. Judge Breyer said that President Trump's call up of the California National Guard was unlawful. He did so on several grounds. He basically said that this wasn't a rebellion or a danger of rebellion, and that he disagreed with the president that he needed this call up to execute the laws. He also said that there were procedural problems with the order, namely that it didn't go through the governor as the statute required. So he basically declared illegal the president's efforts to call up the militia to serve the protective power function to protect federal property and processes, the ICE raids and the like in Los Angeles. I did not. The essential problem here, or the essential issue, is that there's not, in the general scheme of things, much of a challenge right now to federal authority in or to the execution of federal laws, it seems, in Los Angeles. On the other hand, there are these extremely broadly worded statutes that give the president the authority to call up the militia in circumstances that might be satisfied here. And the question is, does the judge get to second guess the president? I was not persuaded by the judge's second guessing of the president. He was very selective in his definition of rebellion. He was not deferential at all on the president's power to enforce the laws. The procedural point I thought is not very important. I wasn't terribly convinced by what the judge said, but I also think that the president could resolve that issue with just a new piece of paper. So, on the one hand, I don't think there's much of a challenge to federal authority here, but on the other hand, these statutes are very broadly worded and dangerously broadly worded, and I'm not sure that the judge made the right call on the law.
And it was notable, he actually granted relief beyond what the government was requesting, did he not?
Beyond what California was requesting.
Yeah, beyond what, sorry, the state of California was
Yeah.
requesting. Yes.
In what sense?
The state of California asked for what it characterized as narrow relief, which was it wanted the National Guard to be and the Marines to be clearly under an instruction that they could not be engaged in what the state of California characterized as direct assistance to law enforcement. He went further than that. He basically unrolled the whole thing. He said that the command of the National Guard had to be returned to the state of California. So the state was asking for one thing, and the judge gave them something even more than they asked for.
He was an extremely generous opinion, and it was clearly they began working on the opinion pretty clearly as soon as they got the papers. It was a 36-page opinion, I think. Um, it wasn't a great opinion. I didn't think. What did you think?
I did not, for one thing, at the beginning of the argument, understand why so much time was invested in the question of whether or not the order had been issued through the governor. I noted, by the way, that in the oral argument at the end, and what I thought was a strange twist, the government more or less pleaded with the judge, if he thought there was some procedural defect, to give them the opportunity to cure it. And he said, and I'm not quoting from the transcript, but roughly said, well, I don't know that I'm in the position of engaging in some sort of negotiation over how you can cure a defect. And then he went ahead and said he thought it was a defect. He said that in the opinion. But as you point out, he started out by just basically rejecting the notion that the president could be afforded a significant amount, for that matter, unfettered discretion here. And he went through this definition of rebellion and concluded that there wasn't any such rebellion. This was a statute. He could construe it. That's what courts do all the time. And he didn't find that the president's construction was consistent with the requirements of the statute. I also do not think this opinion is likely to stand. It's hard for me to see that it would. He could have chosen a narrower path to, if you will, alerting the president to the dangers of his approach, finding some other way to sort of elevate the issues through the opinion that he issued. But instead, I think he made it a somewhat easier target for reversal on appeal and may have missed the opportunity to score some significant points that he could have expressed a different way.
So one point worth noting is there's this old case called Martin versus Mott, that in which the Supreme Court addressed an earlier version, I think a 1795 version of the Insurrection Act, and it concerned the president calling up the militia, I believe, in the context of the War of 1812. And in that case, Martin versus Mott, the Supreme Court, at least as the case is traditionally understood, said that the president gets significant, if not absolute, discretion on the predicates for the Insurrection Act. Again, it's a different statute, but a related statute. And there are ways to distinguish that case. It was a foreign invasion. There's a way to see Martin versus Mott as about the president having exclusive authority to determine the applicability of the statute within the executive branch. But there's language saying that courts have to defer also. And and it's a tough opinion because it basically says absolute deference if you read it to be binding on courts and not just within the executive branch. And he didn't struggle much with that opinion. He basically shoved it aside and instead relied on a district court opinion involving the Alien Enemies Act. And I think of all the unconvincing parts of the opinion, the failure to grapple with Martin versus Mott and to give some modicum of deference to the president on this, I think that was damning and will be the courts above will struggle with that issue much more.
I agree with that. I think there was a way. That was what I meant earlier by saying I think there were opportunities here that the court missed. By the way, I want to talk a little bit about the extent to which the court may have been provoked by the government into taking an aggressive position here. But I do think there was a missed opportunity. He could have distinguished Martin versus Mott. I think it is distinguishable. He could have made a contribution there that I think could have been significant. And the government said some things in oral argument, by the way, also, I think, consistent largely with what they said in their papers, that really presented him with some opportunities. He made something of them in the opinion, but not nearly as much or as centrally as I'd hoped. For example, at one point, the government was drawn into an argument about whether the president needed any evidence at all, any factual support whatsoever for determining that there was a rebellion or a danger of rebellion. And it was a very, very strong statement of what presidents can do. That is to say, they can just announce, maybe in the face of all visible evidence to the contrary, that there's danger of rebellion and invoke 12406 and to whatever collateral degree or supportive degree constitutional authority and deploy National Guardsmen and troops. And that's an extraordinary proposition. I think in a variety of ways, it really actually doesn't stand. But I don't think that Judge Breyer really did enough with that. I just don't think he did enough, even though the government offered him the opportunity to provide some clarifying instruction on what the bounds of presidential discretion might be, even if he ruled in the government's favor in this particular case. What do you think about that?
I mean, I think the whole opinion was slapdash. I mean, it was clearly written very, very quickly. It had a superficial quality to it, but I just didn't find any part of it compelling. It is true that it's hard. It's a tough issue because rebellion has different meanings. He went through the dictionary definitions, and some of the dictionary definitions clearly favor the president. Others weren't so favorable. He chose the one he liked without a very good reason. I just didn't find it compelling. The Ninth Circuit, an emergency panel of the Ninth Circuit stayed the opinion and ordered quick briefing, and they're going to have an oral argument. I think there's going to be a hearing actually on the June 17th. So I guess the question is, what happens now? How does this hand tie the president? For me, I think things just probably get the president's authority. He starts asserting more authority at this point. First of all, in the face of this opinion, the president might win on appeal. He could say, okay, I won't call up the National Guard. I will just use regular military forces and the protective power. I don't need the National Guard, and just send in more Marines. He could invoke the Insurrection Act, the provisions of the Insurrection Act about calling up the militia that don't involve that are more favorable to the president in their definitions and that actually state in them, unlike the statute that this court was relying on, actually state in them that it's the president's call about whether the underlying criteria are satisfied. Those are all, in some sense, more dangerous options. But and in fact, at one point, in a footnote, the district court judge said, maybe if this route doesn't work because the governor doesn't go along, the president has the option of invoking the Insurrection Act. And I think that's exactly right, and that is not a move in a better direction. Do you agree with that?
Oh, I completely agree with that. I, I hope that somebody is whispering restraint into Trump's ear on this one. They should tell him, I would think they would tell him, um, don't go the next step because the aggressiveness with which he is moving. And I want to say something briefly about how this sort of thing, in my view, colors the approach of the courts. I don't think I'm saying anything controversial here. The aggressiveness with which he is moving, I think, is harming his position before the courts. I don't think Judge Breyer capitalized on that as effectively as he might have. But you know what he has said, and Breyer does quote from that. What he has said publicly about the mission, the political motivations, the jumping on this when the opportunity presented itself, the White House gloating about the political opportunity that they now are in a position to exploit. Um, Frankly, the military parade that's pending here on Saturday, his speech to Fort Bragg, a remarkably political, norm busting speech that he gave to troops. All of that, I think, weakens the credibility of the administration and will definitely provoke alarm in the courts. And they're going to react to it. Now, they may not react to it the way Judge Breyer did here. And I agree with you. I don't think it was effective. But I think they will react to it. And I'm not sure that they shouldn't be sending warning signals in the way that the Supreme Court has sent him warning signals about deportation. He needs to be trimmed back on this stuff. And Congress is not doing it. Congress is silent on this subject. And the courts are left, as it has been left so much in Trump 2.0, having to pick up the slack.
But this is a much harder case in which to do that. I mean, the Supreme Court immigration cases you're talking about, in my view, the administration was clearly violating the law, taking efforts to skirt the law, clearly violating due process. And the court intervened in those cases. And in the other emergency docket cases where the president was acting aggressively, but within the law and even perhaps dangerously on some of the unitary executive stuff, the court has gone along with it on the ground that he was acting lawfully. So, I mean, when you the task you're setting to courts is harder here because the president has, whether he's playing politics. I mean, there's clearly a large political element to this. I think there's also a serious legal element about law enforcement. They want to have really aggressive immigration law enforcement. They think they have a lawful authority to do that. They want to protect the ability of the ICE agents to carry out these very aggressive raids. I think the president is in those respects within the four corners of the law. And so it's a much harder context for the courts to send the kind of signal you're talking about, I think. Now, it's but what makes it yet harder is it's massively dangerous. I mean, the background to what you're saying is this is the president sending the military into the domestic sphere, usually, and where you and I have been screaming about for 5 years now, and others. These are extremely broadly worded powder keg authorities that are really open-ended and potentially dangerous if a president is going to be sending in masses of military troops into the homeland for any number of reasons. And so it's in a very dangerous context, but I'm not sure that the courts have a basis, ultimately are going to have a much of a basis to resist the president. I just don't, it's hard to see where the legal argument comes from for me.
Well, let me ask you how you would react to this. I mean, assuming that we were writing an opinion like Judge Breyer's, he could take the administration's legal arguments head on. The administration was asked, for example, what are you relying on here? Well, we're relying both on the statute, but we don't really need the statute because the president has inherent authority. In a striking move in the oral argument, the United States government didn't even get around at the beginning to emphasizing the protective function. It didn't say a word about longstanding executive branch authority dating back to the Rehnquist 1971 opinion. Later, it scurried back to that point when the U.S. government was given an opportunity to get up again after California had spoken. The court could attempt to say, listen, we need more focused understanding of how you view your authorities here. There are statements that were made in the papers and in the transcript of the argument, reflected in the transcript of the argument, that cry out for some kind of response because the administration was slip-slopping all over the place, attempting basically to preserve an argument about absolutely unbounded discretion, untethered to any visible basis for presidential action. I don't know why the government felt compelled to say, for example, that the president could act on the basis of no evidence whatsoever. Why would they make such a statement? And so Judge Breyer could have addressed that much more forcefully and I think still written an opinion that was sort of strong and within the bounds of the law and recognized the degree of the discretion that the president, I think, does have under existing law. But again, up to a point.
Yeah, I didn't listen to the oral argument, and I only skimmed the transcript, so I'm not certain about that exchange. I mean, one thing he could, so you're talking about one of the things you're edging up to is the president's order made pretty clear, and the government's original papers made, I think, very clear that the authority being asserted here is, to use my phrase, a defensive authority to protect the law enforcement function, to protect federal properties. It's not using the military in an affirmative law enforcement capacity. Now, Breyer might have written an opinion that put limits around that and said the authority being asserted here is this protective power, and here's what the protective power means as we understand it, and this is and because the posse comitatus issue was raised, and here's how it intersects with law enforcement, and it could have made articulated some law on where that line between the
Yes.
protective power and law enforcement is. That might have been a very useful thing for the judge to do. He didn't do that. He didn't even go there at all. This was a sweeping opinion that says the president doesn't get deference. There's no threat. There's no danger to law enforcement, and the procedure was messed up. And I just don't think it's going to stand on appeal. I really don't think. I mean, there are narrower options like I just described, but I don't think this opinion will survive.
I agree. And I have to hope that the Ninth Circuit does do what, if in fact it reverses the lower court opinion, I would hope that it does engage with some of what the government has said here and send a clear signal to the administration because things are getting, significantly out of hand. And this administration cannot expect to be credible before the court saying one thing as muddled as they were, and in some respects, as in my view, dangerous as they were in court, and then having administration officials say something far broader, far more aggressive in public. It is not meaningless that the president says that the troops are there to liberate Los Angeles from a migrant invasion. It's not meaningless that presidents make those kinds of statements. He can make them by tweet with lots of capital letters and exclamation marks. These are still presidential statements, and they're going to affect how the courts do and should look at the assertion of authority that he's making.
What is the, so I agree they're meaningful, but what is the force of the should there? I mean, how should a court cite those quotations in an opinion and say, we're not going to trust the president, or we're not going to allow him to exercise these legal authorities because he's acting politically, or he's making a political carnival out of this, or because he's not serious, or because he's acting in bad faith? Those are all really hard things for judges to do in a legal context.
Well, first of all, I think that Breyer did quote the migrant invasion comment, and also his comment to the effect that, quote, we'll have troops everywhere.
But
He also quoted
what's the legal import of that?
well, I think the legal import wouldn't be any different, in my view, than if the president had gone into the East Room and given a press conference or a formal statement to the country in which he expressed that view of what he was doing in California. Why does that not have legal significance? He's the president of the United
Well, what
States.
is the legal? I mean, so let's say he did it at a press conference. I don't see why it matters to the legal question.
I think it's going to affect the courts. I think what the president says about what it is that he is doing, the authority that he's claiming, if it conflicts with either his true legal authorities or what the government's asserting in its papers, is going to attract the attention of the court. And I don't see how it shouldn't.
Yeah. So you're saying that it might, I think you're saying, correct me if I'm wrong, it might not be technically relevant to the legal analysis, but it's going to inform how the courts assess the president's judgment and whether it get how much deference it gives the president and the like. And we've seen this happening in lots of cases. We've seen it happening somewhat in the Supreme Court about how the courts, to the extent that the presumption of regularity is not satisfied, to the extent that the courts think they can't trust the president, then they're not going to cut him any breaks on the law. And in fact, they're going to take all the inferences against him. I
Yeah.
mean, they can't say that on the surface of the opinion.
Right.
And some would claim that if they're bringing that into their opinions, then they're acting illegitimately themselves because the reason should be on the surface of the opinion. But as a matter of reality, I think you're right. And the danger is that the courts will issue bad opinions acting on that impulse. And then we're in the cycle that we're in where the president has plausible legal authority. The courts are making bad opinions. It's going to end up going to the Supreme Court. The court will act more soberly, although it will see the dangers here clearly. I don't know what it's going to do, but I just don't think that this particular opinion is going to make it on appeal.
I don't think it will either. One other sort of last observation, I'm hesitant to criticize the performance of lawyers operating under enormous amounts of pressure. They're going quickly. So I couldn't tell whether the slipshod way that the president's authority was presented to the court, I thought in many respects it was evasive both in the papers and in the oral argument, was a function of just, they're not being very focused under the pressure of the moment, or whether this administration actually is, short of invoking the Insurrection Act, trying to claim precisely the kind of inherent constitutional authority that you rightly said it doesn't have. And I just don't know. I don't know whether they're just back there. You listen to some of the statements that Trump makes and some of the officials make, and you have to ask yourself the question, just exactly how do they see his constitutional authority? He is a president who has once said Article 2 lets me do whatever it is that I want to do. So I don't know. It's hard to tell from these circumstances whether that was a calculated strategic decision or just,
So I didn't,
a tough moment for the lawyers.
so I thought the bad lawyering came in that document to the Adjutant General of California. The procedural glitch that the district court highlighted was just an example of bad lawyering, typically bad lawyering on the front end by the Trump administration. That should have, if there were normal executive branch processes, that legal error wouldn't have happened. I did not think that the brief was bad. I thought the brief was quite powerful, and it didn't assert any overbroad constitutional power, but I didn't see the oral argument. And, I think that there are two things to separate. One is the power, the Article 2 power that they're claiming vis-a-vis the courts, that the courts can't review what they're doing, and they're making extremely aggressive claims there. And then there's the Article 2 power that they're asserting in substance on the ground. And I think that is a more traditional protective power authority where they're on pretty strong ground.
Yes, and it was striking to me that they didn't go with that and try to sort of make a more conventional and more focused legal argument at the outset. But that's where we are, and I think you and I would be surprised if Breyer's opinion stands.
Okay, we'll see. Probably see by next week.
We will. Have a good day.
Take care.